Hi, everybody. Welcome to today's Cathedral webinar. We are coming to you live on December 18th, 2025. You're tuning in for Fair Housing 101 with your instructor, Crystal Banksman, who's the training coordinator of Travoy. My name is Brooke Warrington. I'm the training and development specialist here at the Native Learning Center. We're also thrilled you could tune in for the webinar today. If you could follow along while I read the disclaimer aloud, this webinar provides a summary of fundamental concepts, requirements, and/or procedures within the allotted 90 minutes. The material discussed does not illustrate all possible scenarios that could be applicable. We also have our copyright infringement law printed here. This is just a friendly reminder that the materials are protected by copyright, trademark, trade secret, and other intellectual property laws. Moving forward, if you want to revisit the recording at a later date, or you would like to access the presentation slides, you can do that in the courses section here on the learning platform. I did put a link to the slides into the chat for you just now. And when you want to tune in for a future webinar, you'll just log in like you did today and click on the green banner. We do ask that you join with listen-only capabilities because we are recording the webinar, so it just helps to cut down on audio feedback. And if you find your sound is coming out of the wrong device, maybe you're trying to use headphones or a Bluetooth speaker, you can pull up a list of your audio devices by clicking on the telephone icon, or you might have a headset icon down at the bottom of your screen instead. Even though we ask you to join on mute, we do still encourage class participation. We want to know your questions and your comments, any tech support issues I can help you navigate through, and we'll do all that through the public chat. If you don't yet have that open, you can go over to the messages panel and click on public chat. That'll open up a chat between myself, the NLC staff, your instructor, as well as the other attendees. You'll just come down here to send message to public chat, type what you'd like to say or ask, and you can hit enter or click the paper airplane button to submit it. And if you find that we missed something along the way, you can always use the hand raise feature that's all the way to the bottom right of the screen. And we do have a list of helpful links in the shared notes section. That's just below the public chat. We'd love if you introduced yourselves in the chat before we get started. You could let us know your name, where you're tuning in from. It's great to see all the different tribal nations that are represented, your work or your role in Indian country that probably led you to today's webinar, and your tribal affiliation. If you have one, you might be a tribal employee and not have tribal affiliation. That's okay too. You are also welcome. And then just a final note, we do want to try to avoid clicking on that red menu panel that's all the way to the left-hand side of your screen. If you click on that, it is going to take you out of the webinar and take you to whatever you selected on the menu. So we just want to make sure we don't click on that because it will pull you out. You can always rejoin by clicking on the green banner once again. All right, y'all. It is with great pleasure that I introduce today's webinar instructor, Crystal Banksman. And Crystal, I have made you presenter now.
Okay, thank you very much, Brooke. And good morning, or I guess good afternoon to everyone. My name is Crystal Banksman. Thank you for joining us today. I am the training coordinator for Travoy. If you're not familiar with Travoy, we help tribal communities to build housing and economic developments all throughout Indian country. I have been with Travoy for almost 14 years. And prior to that, then I was an on-site employee for 12 years. So I've done what you guys do. I know the ins and outs and how rewarding it can be and also how challenging it can be. So today we're going to talk about, real quick. We have a question. Is there an option for closed caption? Brooke, do you have an option for that? Okay, no closed caption. I apologize. Okay, so today we're going to be talking about fair housing, and fair housing is something that is very close to my heart. I really enjoy talking about this because I do believe that as housing professionals, it is our job to make sure that our tenants are taken care of and that they are not experiencing any discrimination. So first and foremost, when we talk about fair housing, I know that a lot of people think, well, we just treat everybody the same, right? And that is a nice sentiment, but it's not always exactly true, because there's a difference between fair and equitable. Fair would be that you treat everybody the same, and then equitable would be that you give everybody the same opportunities to enjoy housing. And another thing I hear is, well, just don't discriminate in housing, which is not entirely true either, because we discriminate in housing all the time. We might discriminate against people who have a criminal background that goes against what our policies are. We might discriminate against people who have too high of an income to fit within our housing requirements. So it's not simply just not discriminating. It is following along with what the law is for fair housing. And when it comes to tribal communities, it's even more specific. And so we will go through what those policies are. So the first thing is we're going to talk about the Federal Fair Housing Act. That refers to Title 8 of the Civil Rights Act of 1968, as well as the Fair Housing Amendments Act of 1988 and Section 504 of the Rehabilitation Act. Those acts set forth 7 protected classes under the Federal Fair Housing Act. Those 7 protected classes are race, national origin, gender, familial status, color, religion, and disability status. Now, your state or local jurisdiction may adopt additional protected classes such as age, sexual orientation, source of income, gender identity, or military status. So if you do have some additional protected classes besides the 7 listed here, then those might be either local jurisdiction protected classes, and so you would go ahead and honor those as well. So let's go back for a sec. So when we talk about those 7 protected classes, then some of those jump out and they're just very obvious to us. I think we all know what race is. National origin would be where you are from, so your country of origin, where you were born. And then gender we'll get into, familial status we'll get into more. Color is exactly that. It's the color of your skin. And even though we have race up there, there could be different colors of skin within different races. And that's why that has actually been specified on top of race. Then we also have religion or lack thereof, and our disability status. So let's go into some of these in a little bit more detail. For example, gender. So gender is something that was added to the Federal Fair Housing Act, and then it has been expanded upon a few times over the years. So the initial meaning of gender is just whether or not you are male or female. However, in 2012, HUD did publish its equal access rule that restricts owners and managers of HUD and assisted and insured housing about asking with regards to an applicant's sexual orientation, gender identity, or marital status. At the time, it did not cover HUD's Native American and Native Hawaiian programs. But then in 2016, HUD built upon that rule, and they did include the Native American and Native Hawaiian program regulations to ensure that all eligible individuals and families, regardless of sexual orientation, gender identity, so whether you identify as man or woman, and then marital status, so whether you are married or not, will also have access to these programs without discrimination. Familial status is one that refers to if there are families with children under the age of 18, a pregnant woman in the household, or anyone who is trying to obtain custody of minor children, either through adoption, foster care, or grandparents. They're all protected under familial status. So it prevents discrimination based on somebody's familial status. This law does not restrict the number of occupants to live in a dwelling. So it is not something that's going to say, oh, there's only a certain amount of people who can live there. Your own personal policies are going to dictate what you will find acceptable for how many people can live in a household. But typically, HUD has adopted something called the Keating Memo. This allows occupancy of a unit, 2 persons per bedroom, plus an additional person in the household. You also may have some local laws or state laws that might say something about occupancy restrictions. And of course, you would follow those. But for the most part, your own policies are what going to dictate how many people can live in a unit. So when we talk about familial status violations of fair housing, then we do not want to discriminate based on somebody having minor children in the household or a pregnant person in the household. And that can be that we don't, refuse to rent to them, but that could also mean some things that are within our own policies. So, if a TDHE, tribally designated housing entity, advertised a project as having no children allowed, then that would be a familial status violation. But another potential violation could be if you require that couples who are living in a unit together be married, because that does violate familial status. Another one that I actually see probably the most often, and it doesn't seem like it is something that is intended to be discriminatory. It is something that kind of sounds like it's a good idea, but it's a policy of saying something like, children cannot skateboard on the sidewalks. Why would that not be a great idea? Well, ask yourself the question, is it only children who can't skateboard on the sidewalks? Can adults skateboard on the sidewalks? If the answer is no, then you would change the wording of your policy. Instead of saying children can't skate on the sidewalks, and you would say tenants or individuals cannot skateboard on the sidewalks, because we don't want to specifically call out that children under the age of 18 cannot do something unless there's a good reason why we would say, yes, this only does apply to children. So an example of this would be, I don't know if anybody here has a pool or a hot tub or any other type of facility that requires water. Of course, we don't want to have young children wandering around, falling into the pool and injuring themselves, swimming on their own. So of course we want to still protect these children. But instead of saying children cannot be in the pool on their own, then what we would do is find a reason and a policy that we could lean on to support why we are saying what we are saying. So for example, if in your jurisdiction, you had where there is a child could go and become a lifeguard and get their lifeguard permit at the age of 14, then that tells me that's an acceptable age for a child to swim on their own. And so if you wanted to adopt a policy that said, individuals under the age of 14 must be accompanied by an individual who is age 14 or older, then that would be an acceptable policy to have, where you would not potentially have that familial status discrimination. You would have a policy that is intended to protect, and you have another policy to lean on, such as your jurisdictional requirement of them being 14 years of age. Likewise, if you had something like a fitness center, and of course, again, you don't want to have 2- and 3-year-olds going and working out on your treadmill and elliptical by themselves. What you could do is look at the manufacturer of those machines, what their recommendation is for an age. Typically, what I have seen is that it's usually like around 16. They would say it's not recommended for use for individuals under the age of 16. So you could then put that into your policy that if anybody under the age of 16 wanted to be in there using that equipment, they would have to be accompanied by somebody over the age of 16. And, just going back to another policy that you can lean against in order to establish what your policy is without it being discriminatory. And I just want to let you guys know there's going to be time at the end of all of this for question and answers, but I am happy to answer questions as they come up. I know sometimes as I'm going through it, you might think, oh, wait, what about this situation? And please feel free to type that into the chat and I will do my best to answer that in the moment. All right, the next class. Oh, I'm sorry, Brooke, did you say something? Okay,
oh, no,
sorry. Okay. So our next category of protected class is going to be disability status. This is one of those statuses that I like to say, if we do not currently fall into the category of being a person with a disability, that just means we don't fall into that category yet. We all have the potential to develop a disability and fall into this category. And also the definition of a person with a disability is a pretty broad definition. Under federal, state, fair housing laws, then what the definition of a person with a disability is if they have a physical or mental impairment, which limits one or more major life activities, is regarded as having such an impairment or has a record of such impairment. And not all of our disabilities are visible. In fact, there are many that are not visible. So things like visual, speech, and hearing impairments, cerebral palsy, mental illness, autism or autism spectrum disorder, epilepsy, muscular dystrophy, cancer, heart disease, diabetes, HIV infection, or recovering from drug addiction or alcoholism. And these are just a few examples. But as you can see from these examples, there are many of these that are not visible. So just because somebody does not appear to have a disability does not mean that they don't meet this category of being a person with a disability. So those are just the definitions of the 7 federally protected classes. Does anybody have any questions about those 7 protected classes? Somebody typing. Okay. So when we are talking about fair housing as it relates to tribal housing, there are some differences because there are some specific areas of the Fair Housing Act that we are actually exempt from. So under NAHASDA, IHBG recipients do not violate Title VI of the Civil Rights Act or the Federal Fair Housing Act if the affordable housing project is on land where the tribe has sovereignty or civil jurisdiction, regardless of any other funding that may have been used. The affordable housing project is funded solely with IHBG funds and is located on land subject to state or local law. Or the affordable housing project is funded with IHBG funds and leveraged with non-federal funds located on land subject to state or local law. So basically what that means is that anywhere that the tribe exercises sovereignty, the tribe can limit housing to Native families or tribal members, regardless of the funds used. So, some people read that and they think, well, that means that tribes are not subject to the Fair Housing Act. However, that is only Title VI of the Civil Rights Act. And as you can see, the little green asterisk down there, Title VI prohibits discrimination based on race, color, or national origin. That's 3 of the 7 protected classes. So the other 4, the gender and religion, disability status, and familial status, all will still apply regardless of the funding source or sovereignty. So I'm sorry, Bessie, you had a question. Can someone declare themselves as disabled without a doctor's statement or receiving Social Security disability? How should disability be documented? Maybe a better way to ask it. Okay. So thank you for asking that question, Bessie. If somebody does not have a readily recognizable disability, such as somebody who is in a chair or is visually impaired, so, where you would see them and it is very apparent that they have a disability, then we are allowed to ask if somebody has a disability without asking the nature of that disability. So it would be something that you could ask in your application, such a question like, does somebody in your household have a disability that would, require a reasonable accommodation or a reasonable modification to the home? That's one way that you could ask for it. And then we'll get into more talk about reasonable accommodations and modifications. But yes, you can ask that as long as you are not asking what the nature of the disability is. And you can ask for documentation if that is going to, be something that's necessary. For example, if they are requesting a live-in aid, we do need to verify the need for the live-in aid and the fact that they have a disability. So you are able to ask that, and there's a really great HUD form that will ask that. So we'll get into that a little bit more, Bessie, but hopefully that answered it enough for now. Okay. So when we are looking at what our prohibited practices are under the Fair Housing Act, we cannot refuse to rent or sell housing based on one of those protected classes, or refuse to make housing available, imposing different prices or rental charges based on being one of those protected classes. So, for example, if you had a family of 4 and you're going to charge them more for the same unit simply because they have more people in the unit, then that would be imposing different sale prices based on a protected class. If you are using different tenant selection criteria, providing different information, evicting any tenant on a protected basis or characteristics of a tenant's guest, using different policies or procedures for eligibility other than those allowed by regulation, failing to provide all rights and remedies, restricting housing choices, or steering. So steering refers to trying to encourage somebody or only telling somebody about a certain housing choice to avoid having them select a different house. So an example of this would be if you did have that same family of 4 and there were 2 houses available. One was in an area that had, lots of children who were out playing and loud and having a great time. And then another area that was, didn't have as many children, a little bit of a quieter section. And, they came in and they had young children, and you said, oh, I don't want to put them in that, really quiet section because that might upset the other neighbors. So I'm only going to offer them the house that's in the neighborhood section with these other children. That's considered steering, and it is prohibited. Exaggerating drawbacks or not providing information on the desirable features of a unit is prohibited. If you assign a person to a particular section of a community or floor of a building. For an example, I actually had this happen to me when I was on site. I had a woman who came in to apply for a unit. I had 3 stories, and I had a 1-bedroom on the first floor and a 1-bedroom on the 3rd floor. She came in to rent a unit, and she was in a wheelchair. Now, if I would have just told her about the 1st floor unit that was available, that would be considered steering or assigning her a unit based on her protected class of being a person with a disability. Would I have been malicious if I would have said that? No, absolutely not. I would have been probably trying to take into consideration the fact that she was in a chair and might not want to have a 3rd floor. However, that is not my decision to make. It is the applicant or tenant's decision to make, and I don't know what their limitations are and what their abilities are. So I did offer her both units, the 1st floor unit and the 3rd floor unit. She did choose the 1st floor, but again, that was her choice, and it's not up to me to make that decision for her. And then also discharging or taking adverse action against an employee, broker, or agent is also a violation of the Fair Housing Act. So if you had an employee who said, I am not going to discriminate, I'm not going to force this family into the family section of our units, and they were then subsequently fired for that, then they actually have been discriminated against, and they would have a fair housing lawsuit available to them. Also, in our rental policies, we kind of talked about this earlier, we want to avoid any potential discrimination in our rental policies. So that could be imposing different terms, conditions, or privileges based on a protected class, denying or limiting services or facilities. One that I see with this a lot is if somebody has a service animal and they are told you cannot bring your service animal into the office, or you cannot bring the service animal into our community building. That would be limiting the service or facilities based on their protected class of having being a person with a disability and having a service animal. Using different provisions in our lease or contracts, denying or limiting discounts, rebates, or gifts. So if you were to give a discount or some sort of an incentive for folks that worked for a certain employer, that actually could be discrimination, because there could be people who have a disability who are unable to work. And if they're not afforded the same discounts, then that could be discrimination. Failing or delaying maintenance or repairs of a unit. I actually had this happen to me when I was an on-site manager, and we had a woman who was diagnosed with schizophrenia, and she would have frequent maintenance requests, and sometimes my maintenance supervisor would get a little frustrated with those requests, and I would put a request in, and he'd say, I'm not going over there, I'm not going to do it, she's crazy. And unfortunately, we cannot limit, or fortunately, we cannot deny maintenance on somebody's unit because we do not like them or because they are of a protected class. And so it is discrimination if he was to not repair her unit based on the fact that she had a mental illness. And then also limited the use of services or facilities in a project. So these are all prohibited practices and prohibited policies that we would not want to have in our fair housing policies. So Betsy, I promised I was going to come back to our reasonable accommodations and modifications. So we can now talk about those. This is for anybody who is a person with a disability. A reasonable accommodation is a change to a rule, policy, or practice that might be necessary to allow a person with a disability the equal opportunity to use and enjoy the dwelling. So this would be something we would change our policies in order to accommodate them. A reasonable modification is a physical change to a dwelling or common area, like ramps or walk-in tubs, flashing doorbells and fire alarms. If somebody is hearing impaired, then those will light up. Roll-in showers, grab bars, lowered mirrors, wider doorways, lowered cupboards or peepholes, a side-by-side fridge, or as holler toilets. Also removal of carpet. I have had that happen where a woman she used a chair and the carpet was inhibiting her chair, the wheels on the chair. And so we did remove that to put non-skid flooring in. And then air conditioning. Air conditioning can actually exacerbate some conditions such as asthma. So if you don't have air conditioning, they might request that. Or levered door handles. So these are all examples of reasonable modifications. So this is a physical change to the dwelling. If federal funding is used, the modification must be made at the property's expense. And the property owner does the work. And if there are any permits that are required, those are paid for by the property owner. If you're going to require that it is restored when the tenant moves out, it's going to be at your expense, not the tenant's expense. Now, the modification that they request cannot cause an undue financial or administrative burden. So if you can prove that the requested accommodation is not reasonable, then you do not have to provide it. And if you cannot prove that, then it does have to be provided. So again, that could mean that it causes an undue financial or administrative burden. If you do, then you should always try to find an alternate solution that would be equally effective but less expensive. So some examples of unreasonable modifications would be removal of a load-bearing wall, adding a bathroom, installing an elevator, or installing an expensive step-in tub. Those all could be considered unreasonable modifications. So again, you would want to try to find another solution. So let's say that we had somebody who came in and they said, I have a disability. I'm going to have a live-in aide come and live with me. And I'm only in a 1-bedroom, so I need you to build a second bedroom on so that my live-in aide has a place to live. That is obviously unreasonable. And so you would say, unfortunately, we can't honor that request. However, we can transfer you to a 2-bedroom, and that would be equally effective and less expensive. Now, the necessary component of a modification or accommodation is that it will remove a rule, policy, or practice that interferes with the person's right to use and enjoy the dwelling. It will improve the tenant's access to the unit by removing some architectural barriers, or enhance the tenant's quality of life by minimizing the effects of that disability. And it would enable the tenant to satisfy the essential requirements of tenancy the same as a non-disabled person can. There does have to be something called a nexus. A nexus is a connection between the disability, the requested change, and the ability of the individual, of the person with the disabilities, to use or enjoy the dwelling. So determining whether there is a nexus. For example, we've got a tenant who has been diagnosed with PTSD, and his condition is exacerbated by loud noises. The tenant requests a transfer to a quieter unit and the ability to install soundproofing. In that situation, there is a nexus. There is a connection between what the disability is and what the request is. However, let's say that same tenant who has been diagnosed with PTSD and has a condition exacerbated with loud noises requests an accessible parking space. There is no nexus. There is nothing that having an accessible parking space would do to limit the condition and those kind of loud noises. Again, when you are refusing a requested accommodation or modification because it's not reasonable, discuss with the requester whether there are alternatives that would effectively address their disability-related needs. All right, Carmen has a question here. Someone requesting a taller toilet because they can't get up from a lower one. Yes, that would be a reasonable modification. So if they were a person with a disability and they were unable to, use that, and they want maybe a taller toilet, some grab bars installed, something like that, then that would absolutely be a reasonable modification. Good question. Now, this goes back to the previous question was, can we require them to get verification on that? I know that I have had lots of tenants who are very happy to do this. In fact, sometimes they're too happy. They might come in and say, here's all of my paperwork about my disability. And we really do not want to have people's medical records in our files. So if somebody comes in and says that, say, thank you so much for being so accommodating. However, because we want to protect your privacy and HIPAA laws, then we are just going to do this basic verification. So you can send a verification that requests information that is necessary to verify if they have a qualified disability. You would describe the requested accommodation in your verification request. And it needs to show the relationship between the disability and the need for an accommodation. If their disability is obvious or known, so you already have prior knowledge about that, then you might need to say, okay, well, is there a reason why we have to have this requested accommodation? If you know that, you don't need to ask for any information. If you have a disability that's known or obvious, but the need is not, only ask the information necessary to verify what the need is for that accommodation. If neither the disability nor the need is readily apparent, then you can ask for verification of both the disability and the need for the accommodation, but never request records that would disclose the nature of the disability. HUD has a really nice form that it just asks 3 questions. So you would send this over to a physician. It could be a social worker. It could be a clinical psychologist or a therapist. And you would just tell them, who you are, who the person is, what they have requested. And then you would ask 3 questions. 1, does this person have a disability as defined by the Americans with Disabilities Act? 2, will the requested accommodation allow this individual to enjoy the premises as other non-disabled tenants would? And 3, would you testify to this in a court of law? That third one is to just kind of protect you a little bit, because we all know that, sometimes physicians will write a letter for anything, right? Sure, I don't care, no skin off my nose. However, if their license is going to be called into question, then that might make them think twice about signing off on something. And so we really like to have that third question that says, will you testify to this in a court of law? And I will get that form for you, Bessie. It is, like I said, a HUD form, so I'll get that information for you as well with the exact number for that. And Brooke, maybe we can post that with the slides as well. All right. Any questions before we move on to assistance animals? Okay. So this is probably the biggest reasonable accommodation that we see, especially as of late. That is when somebody would request, because they have a disability, that they get an assistance animal or service animal. The difference on this is that a service animal is an animal that's actually individually trained to do work or perform tasks for somebody with a disability. Service animal could be like a guide dog. It could be, there's lots of really amazing animals out there who can do some amazing things. There are parrots out there that can actually smell their owner's breath to determine if they have low blood sugar, if they have diabetes. There are dogs that can sense when their owner is going to have a seizure. And they can actually, they lay down on them to make sure that they do not hurt themselves when they have that seizure. So there's lots of animals that are trained to do work to assist somebody with a disability. However, there are also other types of assistance animals, such as emotional support animals, that might not necessarily be trained to do work, but they still alleviate some symptoms of somebody's disability. Now, it's important to remember that assistance animals and service animals are not pets. It's an animal that provides assistance for the benefit of a person with a disability. If they have tasks that are performed, they should be directly related to the person's disability, but it is illegal to charge a pet deposit or a pet fee for an assistance animal. There are no breed, size, or weight restrictions that are allowed. So I know that the one I hear a lot is pit bulls. Okay, well, we don't allow pit bulls. However, that will not apply if somebody has a pit bull that is an assistance animal or service animal. Even if the nation has a policy against it, even if your insurance company says that they have a policy against it, you cannot deny it based on the fact that they are a pit bull. Same with size or weight restrictions. There are no restrictions about who can train the animal. So it could be the individual themselves, or it could be an outside company, but there are no restrictions on that. There's not even a requirement that the animal is specially trained, and you cannot require that they have special tags, equipment, certifications, or identifications. I think we all know also that we can jump on Amazon right now and we can get one of those cute little vests that say service animals. So even having one of those is not going to prove or disprove if somebody has a disability and requires an assistance animal. There are also no species or limitations on the number of animals allowed if each of those animals provides a service for a different disability. So, we do know that there are people who have multiple disabilities. You could have somebody who has diabetes, but then they also might be, hearing impaired. They might also have mobility issues. And so if they have different animals that serve different purposes, they are allowed to have multiple animals. So let's say we had somebody who was hearing impaired, and they had diabetes, and they were mobility impaired, and they had, and then they also had depression. They could have a cat for their depression. They could have a parrot for their diabetes. They could have a dog to help them with mobility, and then they could have another animal that would help with the hearing. And so if they have different needs and each one of those animals serves a different need, then we cannot limit that. Now, if we have somebody who comes in and says, I have depression, I need my 20 service cats for my assistance animals, then yes, of course, we can deny that. They cannot have multiple animals for one specific disability unless you allow that. We actually had this come up not very long ago where we had somebody who had lovebirds, and the lovebirds required to be a pair. And so the TDHE they said it was okay that they had 2 of them because those animals came in pairs. That's up to your policies, but that's just an example of something that came up recently. So when can we deny an assistance animal? If the specific assistance animal in question poses a direct threat to the health and safety of others that cannot be reduced or eliminated by another reasonable accommodation. Or if that specific assistance animal in question would cause substantial physical damage to the property of others that cannot be reduced or eliminated by another reasonable accommodation. So if you have somebody who has a dog, and that dog attacks another tenant, at that point, you can say you can't have that assistance animal. Likewise, if you had somebody who had a live-in aid, and the live-in aid was selling drugs out of the unit, you can say you can't have that live-in aid because they present an issue. And I actually did have this happen to me once when I was on site. I had a woman who had a dog that was an assistance animal, and it attacked one of the other tenants. We told her that she had to either get rid of that dog and get a different dog, or she had to move. She did opt to move. She did actually press charge or sue us for a fair housing violation, and we did win because we allowed her to have an assistance animal, just not that specific one. And then again, if it will cause substantial physical damage. So if somebody says, I'd like to have a full-size horse in my unit as my assistance animal, I think we all know that that would cause some pretty significant damage to the unit if we had a full-size horse in there. And so you would be able to say, no, I'm sorry, we can't have that, but let's look at something else, maybe a miniature horse. Those are actually allowed to be assistance animals. So here's a flow chart that you can kind of ask yourself questions on whether or not this would be a reasonable accommodation and if we should allow them to have a service animal. If it is required because of a disability, then we're going to ask some more questions. If it is not required because of a disability, we do not have to allow the animal. If it has been trained to perform specific tasks, then we pretty much automatically allow it. If it's not, we're going to ask if the person has an observable disability or if it's known. And also, is it a common animal? Something like a bird, and a cat, a dog, a miniature horse is actually considered a common animal. And so then we would allow that. If it is not, if it hasn't been trained, or if it is not a common animal, that doesn't necessarily mean no. We might just have to ask some more questions about it. So that is the end of the animal discussion. Does anybody have questions? I usually have a lot of questions about the service animals. Okay. I guess I just did a great job explaining it, right? Okay, the next thing we're going to go into is just real quick, we're going to talk about disparate impact. If you have not heard of what disparate impact is, this is something that has come up within the past, decade or so. This is a policy or practice that on its face looks like it is something that is a good idea, and it is something that would protect you, your tenants, but it disproportionately harms minorities without a valid rationale. So under the Fair Housing Act, policies can be considered discriminatory if they disproportionately affect any of the 7 protected classes without a legitimate, non-discriminatory business need. So this really came about from the Texas Department of Housing and Community Affairs versus Inclusive Communities Project. This is what enabled the Supreme Court to rule that disparate impact claims are valid under the Fair Housing Act. So here are some statistics that we are going to talk about when it comes to criminal policies. Nearly a third of the U.S. population has a criminal record of some sort. And in 2012, the U.S. accounted for about 5% of the world's population, yet almost 25% of the world's prisoners are held in American prisons. About 650,000 people are released annually from prison. And in the U.S., Black, Indigenous, and other people of color are convicted and incarcerated at disproportionate rates compared to their share of the general populations, and typically receive harsher sentences for the same crimes as their white counterparts. So when we are looking at our criminal history-based restrictions in housing, we want to make sure that we are not going to have anything that where the burden falls more on individuals of one protected class over another. The biggest thing that we see is when a housing authority or department says no criminal history at all. If you were to say that nobody can have criminal history, then you would be limiting a large part of the population, and sometimes without good reason. There are lots of different things that people can do to have a criminal background that might not necessarily impact their ability to be a good tenant or a good neighbor. If it does not serve a substantial, legitimate, and non-discriminatory interest of the housing provider, or if such interest could be served by another practice that has a less discriminatory effect, it could be a disparate impact under the Fair Housing Act. So, for example, landlords who reject Black or Latinx applicants because of criminal records but accept a white tenant with a similar criminal record could be found guilty of violating the Fair Housing Act. The other thing that we see is exclusions because of prior arrests. HUD has clarified that arrest records cannot be used as the sole reason to deny housing, terminate assistance, or evict tenants in public or federally assisted housing. So having a policy that says if you've ever been arrested for a crime or have pending charges, then you are denied, that could be discriminatory. There is a statutory exemption of that. It is from Section 807B4 of the FHA, and it allows providers to exclude individuals who have been convicted of producing meth on the premises of federally assisted housing, or if they are subject to a lifetime registrant on the sex offender registry. So we do not want to automatically discriminate and say if you've been arrested for something, then you are not eligible to live here. And if we do have some criminal policies, we want to make sure that that is something that is reasonable and is not going to be disparate impact against our tenants without good reason. So if we look at some of these examples, we've got Scott Lang, who's 45 years old. He was convicted of felony burglary and theft when he was 22, and he was denied a rental unit based on that conviction. Is this reasonable? And I'm not going to tell you one way or another how to make your policies. It's just to start that conversation. He's 45 years old. He was convicted of felony burglary and theft. Of course, we don't want somebody living there who has robbed houses before and would be a danger to our other tenants. However, this was over 20 years ago, and he has not had any criminal record since then. Is it reasonable for us to deny him based on that? Or should we put a time limit on that? And what is that time limit? What do you think in your housing policy, what is a reasonable time limit? 5 years? 7 years, depending on what the conviction is. Also, we've got Peter Parker here, who was 19. He was arrested for assault last year and was denied a rental unit based on that arrest record. We would not want to deny somebody based solely on their arrest. I think we all know that people can be arrested. They could be falsely accused of something. They could be falsely arrested for something and be released. So if they are being denied solely based on their arrest record, then we're definitely going to want to re-examine that and change our policy for that. Tony Stark, he's 35 years old. He was convicted of embezzlement 3 years ago and denied a rental unit based on his conviction. Well, it was only 3 years ago, but it was embezzlement, which means he stole from his employer. It's up to you and your policies how you guys would treat that. I would definitely not hire him, I'll tell you that. But would I maybe let him live in my units? Potentially. And then our last one, Carol Danvers is 37, convicted of distribution of a controlled substance and denied a unit based on her conviction. That one we need more information on, right? So it could be that this was something that was, distribution, it was from 20 years ago. Could be that it was from last year. We need more information before we can make a good decision about whether or not we should deny that one. So filing a complaint, anybody who feels that they've been discriminated against may file a complaint with HUD or a state or local agency. It must be made within 1 year of the date of the event, and it can be filed online, by mail, by fax, or by calling. And it's any aggrieved person. That includes housing applicants, their spouses and children, current tenants, fair housing testers who are given false information. These are people who are hired to go around to see if people are giving discriminatory information out there. And if they feel that they are being discriminated against, then they can also sue. And then fair housing organizations can also sue. Who can be held liable? Property owners, lenders, insurance companies, housing authorities and departments, homeless shelters, subsidized housing programs, assisted living facilities, HOAs, and then managers, assistants, occupancy, and maintenance personnel can all be held liable. And you can be sued individually for up to $250,000. I don't know about you guys, but I don't have an extra $250,000 laying around. And so I definitely do not want to be held liable under this, especially for something I was just doing in the normal course of my job and I was following rules. The legal ramifications for violating the Fair Housing Act, you could have compensatory damages for a lost housing opportunity. Also punitive damages for egregious, willful, and pattern behaviors. So compensatory damages are to compensate somebody for something they've lost. Punitive damages are intended to punish the person who has caused the damage. attorney's fees and costs, injunctive relief, and you could potentially have criminal prosecution if it is determined that it is a violent or hate crime. Ignorance of fair housing laws is also not an excuse that will avoid liability. So I'm happy that you guys are all here today learning about these things so that you can mitigate your liability and make sure you go through your policies and determine what you need to change, if anything, to make sure that you are within the requirements of the law. So here are just some questions to ask to see if this is a fair housing violation or not. Let's say as part of a background check, TDHE learns that an applicant has poor housekeeping habits, and the TDHE denies the applicant based on this information. Are we allowed to go back and see if somebody has poor housekeeping habits? We can, absolutely. If you have somebody living in your homes right now and they want to transfer to one of your big, new, beautiful LIHTC, ones that you're building, but they don't take care of the existing one, yeah, we can go back and say, no, we're going to deny it. That on its face does not have any fair housing implications. Now, if you go back and you find out that this person has been diagnosed as a hoarder, which is something that has been added to the DSM, then we might be talking about a different situation. But as it is described right now, it would not be a violation. A tenant uses a wheelchair and wants a small wooden ramp constructed at their door to easily access the unit. He asks the TDHE if he may hire someone to build a ramp. The TDHE thinks the ramp will not look good and denies the request. Yes, this is absolutely a fair housing violation. Just because we don't think it's going to look good doesn't mean we can deny it. Now, the solution to this would be that the TDHE would build the ramp for them and make sure that it does look nice. Next one, in checking references on an application, the executive director discovers that the applicant has a history of mental illness. The applicant has no criminal record, but the TDHE does not want to rent to him because he could be a danger to other tenants. Yes, this is a fair housing violation. We cannot anticipate that somebody might commit a crime or do something inappropriate. If they do, then we can address it at that time, but we can't anticipate it. Next one, a project has a policy of only one pet per unit, and they deny an applicant because they have a service dog and a companion cat. Yes, this is a fair housing violation. If they have 2 disabilities and they need 2 service animals, then we do have to allow them to have both of those service animals. And the last one, an apartment complex does not assign parking spaces. A mobility impaired woman asks for a reserved space near her building. The landlord refuses, stating if they do it for that tenant, they must do it for all tenants. Yes, this is a fair housing violation. If somebody is mobility impaired, they ask for a reserved space, then you would want to honor that. I had this happen to me at an elder facility that I managed, and yeah, they all started talking, and I ended up reserving all of the spaces at some point. But I did not violate the Fair Housing Act, and that was the most important thing. So examine your own policies. After we've gone through this discussion, then you might think, oh, I don't know, that policy might, be worded a little bit strangely, or it could potentially be a violation of the Fair Housing Act. I'm not here to tell you what your policy should be, just to encourage you to look at them and see if there's something that you can do to improve those policies, and also just to improve your disclosure of what our tenants' rights are under the Fair Housing Act. It is our job as housing professionals to inform our tenants of these things. And so we want to make sure that we are being transparent in all of that. Rachel, you had a question, sorry. What if a tenant has a disability and wants a unit close to the main door of the facility? If there is a nexus to those things, so if they have a disability and they don't, are not able to walk a long distance, and so they want to be closer to that, and they make that request, and you have a unit available there, then yes, you could absolutely consider that to be a reasonable accommodation, and you would, like I said, as long as they have a disability and there's a nexus, then you would want to go ahead and honor that. Good question. All right, so are there any other questions? Is our little question and answer opportunity? All right. Well, I will I'll stick around for a little bit, so in case anybody thinks of anything. Or you also have my contact information. You can reach me at crystal@travoy.com, and I'm happy to answer those questions. Thank you, Juliet. Brooke has put a feedback survey in there, so please do take that. We like to take all of that information and improve these classes for you. And thank you, Richard. Been nice talking with everybody today, and I hope everybody has a wonderful holiday season. We do have another webinar coming up after the holidays on Inspire. So hopefully we'll see you back here for that. Yes, I do have the disability form. And Brooke, is that something that I can put in the chat or something that I
yeah, if you have a link to the form, you can put it in the chat. That's fine.
Okay, great.
Yeah. And then I'll just go through the outro, give you some more time. Yeah, as she said, I did put a link to the webinar feedback survey into the chat for you guys. It's in the chat as well as in that shared notes section. It is anonymous. It just takes a few minutes to complete, and it helps us at the Native Learning Center know what's working and what we can improve upon. And as Crystal said, we do have one more webinar for 2025. That won't be next week. That'll be the following week on Tuesday, and that's on Intro to Inspire. And you can check out this as well as our other recorded webinars on our YouTube channel. We have a whole playlist called the Cathedra Webinar Archive, and that goes through our webinars for about the past 2 years. And we hope you can check out our other upcoming events. We post about them to our various social media. We're on Facebook, Instagram, LinkedIn, Twitter. If you are a podcast fan, we have our own podcast, the Hope a Thing, a Native American podcast. You can listen to that wherever you listen to your podcasts. And then we also have the recorded videos with our guests on our YouTube channel as well. Otherwise, that is all we have for you folks today. Thank you so much, Crystal, for an incredible presentation, a lot of information. And thank you to everybody who attended. I'm going to put that webinar feedback survey one more time for you in the chat. Otherwise, happy holidays, everybody.
Thank you.